Accusations of the rights of the accused being violated, angry remarks from Judge Chifiwa Maumela informing Advocate Malisela Tifo not to tell him how to run the Senzo Meyiwa murder trial, and accusations of police incompetence. Another dramatic morning. Dramatic day indeed in court. Let's get some views and analysis from legal expert Zola Majavu from Majavu Incorporated. Mr. Majavu, good afternoon. Thank you very much for your time again. Drama, and drama, that will be a layman's term like myself to sum up what we witnessed this morning. But I want to take you back to that Advocate Tifo's exchange with the judge, where the judge says it's not going to be the case of the tail wagging the dog. You won't tell me how to run this trial. What was that all about? How do we interpret that exchange?
Good afternoon to your viewers, and thanks for having me. I think the judge was spot on. It was about time that he draws a line in the sand. And this is what brought it about. Advocate Tifo sought to introduce an issue at a moment that all lawyers who are properly trained would know that it was inopportune. He indicated that the continuation by the cross-examination, not by himself, but by Advocate Mshololo, who was perfectly entitled to proceed, was an exercise in futility. It is not his place to make that call. Advocate Mshololo was perfectly entitled to continue the cross-examination that stood down from the previous day. He sought to mention something about a confession. And confessions are typically some of the tactics that are normally resorted to by the state. Because a confession is a voluntary act where you, brother, say, I confess or I agree that on such a day I committed this offense, and I did so freely and voluntarily. Armed with that, the state would be entitled then to introduce that confession at a point that it determines appropriate. At this particular moment, Advocate Tifo had finished cross-examining on behalf of accused number 1 and 5, and therefore it was rude of him, in my view, to then make a call about whether or not Advocate Mshololo would achieve anything by persisting with the cross-examination that stood over. And the judge was correct to say, no, that's not your call. Secondly, the confession is not even on the table. A confession, whether correctly or incorrectly obtained, is triggered by the prosecutor when he or she decides, I now want to introduce it into evidence. If he does so, at that point, then it is open to a defense counsel, such as my colleague Advocate Tifo, to say, Judge, I object to the introduction of this evidential material for the following reasons. Now, because we are busy with a main trial, I am applying for the issue about the admissibility of that confession to be determined in another process, which is called a trial within a trial, meaning a mini trial along the sidelines of a main trial. Absent the prosecutor triggering or signaling his intentions to reuse or to rely on a confession, it was definitely offside for my colleague to seek to talk about it at the time when he did. And because he was not getting it with respect, that warranted the judge, and correctly so, to say, no, hold on. You are not going to persist with that line of argument. There is no confession before me. If and when it gets triggered, we will deal with it at that time. And that's how the exchange got about. And I thought, personally, the judge was very lenient, but he got to a point where he had to assert his authority as a presiding officer, and he did that quite well. He did not suppress Advocate Tifo and Julie. He simply said, hold on, you had your time, you didn't raise these issues when you should have, and Advocate Mshololo's time is being now taken away by you when you ought to have known the procedural processes. You should have known at what point a confession is triggered, a trial within a trial is triggered, and how you do so. So he was spot on, in my view, I think rather belatedly, because I have high regard for Advocate Tifo, but sometimes the way he rewrites the rules of procedure is baffling, to put it mildly.
Okay, could we see that trial within a trial? I don't know what's going to happen come Monday. And I'm asking this because he also made the claims that the rights, his clients were not read their rights, accused 1 to 4, and that they are being scapegoated in this case.
But that is not before the judge. When he cross-examined for over a day or so, he could have taken that point. But he's talking about what happened in Boksburg. When this matter got underway, Advocate Baloyi made opening remarks to paint a scenario and to orientate the court in terms of how he is going to proceed. Similarly, Advocate Tefo and Advocate Mshololo had an opportunity to make the opening remarks. At that preliminary moment, he could have taken the point that he now seeks to take, not when he's on his feet, when a colleague is on his feet. And therefore, one fails to understand what constitutional rights is he referring to at this stanza of the proceeding. So quite frankly, I think it's a side issue. The procedure is that if Advocate Baloyi on behalf of the state decides, when he does so, to introduce a confession, only at that stage can the representative of the person affected by the confession could then raise an objection. And the way procedurally to determine whether there is merit or otherwise in that contention is through a trial within a trial. If we get to that point and a trial within a trial does eventuate, one or two things can happen. The judge can either rule that the confession was properly obtained in that it was done so voluntarily, freely, and it was also reduced to writing in the presence of a magistrate or a justice. Or he could find that there is no merit in the contention that the confession was properly obtained, in which case he throws it out. And if the state's case was hinging on a confession, then they're in trouble. But if the state's case is not hinging exclusive on a confession, then Advocate Baloyi will simply call the next witness and the trial continues. There is absolutely no moment to the sideshows that we are watching.
Yeah, the dramatic side shows indeed. Now, just to get your sense, Mr. Musia today not feeling well, and then the judge had to adjourn and postpone it to Monday. The sense I'm getting is that it looks like Advocate Mshololo is trying to prove about the incompetence of the work that was done at the crime scene, when earlier we saw Advocate Tefo and using the word contaminated crime scene. Is that the defense will try and do mostly in such cases, to try and expose some failings in how evidence was being gathered at the crime scene?
It is absolutely spot on. That is what any defense would focus on, because remember, if you manage to prove that the handling of the crime scene was contaminated, it's like showing that anything that flows therefrom is fruits of a poison tree. And that is precisely why it would make sense for the state to start with a crime scene expert first and build up from there. So if they succeed in demonstrating that Mr. Musia did a shoddy work, then they are well on their way to demonstrating that the case state was built on very poor edifice. And if you ask me, I thought Advocate Mshololo is on point. She is trying to demonstrate that with less theatrics, but with more pointed questions. Because the difficulty, if you ask open-ended questions, if you put theories, you are going to get a convoluted response from a witness. So without taking anything away from Advocate Tefo, he did as best as he could. I think what you have picked up, which is spot on, Advocate Mshololo rightly is trying to discredit Musia as a witness, and also indicate that flowing from the shoddiness of his work, which he has considered in some instances, he ought not to be trusted as a credible witness, and therefore his testimony ought to be attached or accorded less probative value. So that approach is correct. Whether or not they have punched sufficient holes, we don't know. But remember, when they are both done, that is Advocate Tefo and Advocate Mshololo, Advocate Baloyi, on behalf of the prosecution, has an opportunity to re-examine. That is what we call a fixing up exercise as lawyers in our own parlance, which means he may ask questions to enable the witness to bounce back or to clarify where he might have been misunderstood. So the sooner we get down to that, the better, because otherwise the allocated time during this term is not going to be nearly enough for significant strides to be made in this case. And that can hardly be said to be in the interest of the accused persons who are behind bars.
So could we be in for the long haul? Has it happened that the allocated time is extended?
Oh yes, we in for a long haul. Just to give you a sense, if 2 weeks was allocated, at the rate we are going with these side shows, I do not see how much progress we would have come by next Friday, covered by next Friday, because remember, we are still on witness number 1. We haven't yet heard other witnesses, the blood spatter expert, for example, or other eyewitnesses that the state may have lined up. Of course, the defense is in possession of all the statements that the prosecution is going to rely upon, which is why Mr. Tefo maybe jumped a bit inopportune, because he is in possession of that confession or whatever document he was referring to, because the state has a duty to make all of that available, whereas there is no inverse duty on the defense to make whatever statements they intend using available to the prosecution. So this trial is not going to be over this term. It's not going to be finalized next term. And remember, there are other equally competing cases that must still be prioritized on the road. So we are in for a long, long haul.
We're going to see how well Mr. Musia will feel on Monday as he resumes the evidence seat there. Thank you very much, Advocate Zola Majabu from Majabu Incorporated, giving us some insights and a sense of what happened in court today.